Are you ready?
Yes, Judge, we have several arraignments, but they have attorneys.
Okay. Herman, do you have one?
I don't have an arrangement.
It's okay.
I have some, if you're ready.
Yeah, come on. Talk to
Simone
me.
Williams, she's going to PTI, she's president, everything's been turned.
Are you waiting on anything? Are they ready to file the supervision? Do you have, so you've gotten the contract, when did you get the contract?
Well, we need approval, I guess, everything's been turned in.
When did you turn it in? Why is it taking so late? My
It's,
goodness, it's 220 days
I have a
old.
note that the application and issuance was saved yesterday.
yeah. That's why Ms. Williams is here, Judge.
Okay, so let's give it till next week, you know? I'm not doing a long reset. It's 220 days old, so pick a day
Has she
next
done a
week.
TRAS yet? Will we do a walk with TRAS when she's here?
Do you know that you're gonna get
I'm confident, I mean, it's
anything?
it's only a 1.6, I mean, a 1.76.
There was an accident,
Any priors?
no, Judge.
Do you want to?
Yeah, I think
Okay.
it'd be
All right,
efficient.
we'll send them now since we're here and then
Okay, thank you.
hopefully, yeah, okay.
Thank you.
All right, so we'll set you off like 2 weeks,
Okay, cool.
but it's got to be done, Herman, by that point. If it's not done, I'm rolling your day for
Yeah,
day.
you want to admonish me?
No, you do it.
Okay.
It's just, you know me. I mean, it's at then you're nearly 250 days. You don't have done day for day.
Okay.
Okay, I trust you.
I'll be back. It's gonna take me a minute to do that, but I'll be back.
Hey,
Dr. Moore,
how are you?
pretty good.
Go have fun.
Later on this morning.
Go have fun.
Huh?
Go have fun.
I will. I'm going up there.
Okay, good luck up there.
See, I'll let you know.
So I'm gonna spin it when I'm here, being outside. Oh, no, yeah. 16%. That sounds good. Yes, Ms. Williams, final up, please.
Oh,
Okay. Ms. Williams, in just a minute, we're gonna sign, maybe to come back to April 16th. We might not have to come back. You're gonna have to further that review this in the right here, and we're gonna go through the evaluation, so we can put you in hopefully by April 16th. And then what's it? Okay. Yeah, we're gonna do it. Yeah, we're gonna bring it out the stats for the deputies to give it to them before the job. And we go over the session, okay?
That's on Tuesday.
Questions?
Shoot. No, hell no. Why delay the inevitable? Oh, sorry. Domino's Pizza. Are they here now? You talk about the bottom, right? Okay, I'm glad that they finally got it in, but I mean, when is the schedule? Right, let's see if it shows. And then we'll go from there. Hi, Dan.
Hey, morning, Joe.
Hey, so just for future awareness, just because they put something in the queue, I'm not, you gotta approach on it and then we'll talk.
Right, so the other day when I came here to do that, and I was putting it in a queue right as you left the bench, so.
Yeah, I had to run to get my
Yeah.
kid. The only problem I have is I don't know that they purchased the gun, that it's theirs. I've given a gun back before and it wasn't the person's gun, and then I had a bunch of people come at me crazy. So now, to make sure that it's their gun, I need some kind of showing, did they get it at, do they have some kind of proof of purchase? Do they have
Doesn't the state have a
anything?
database, serial numbers and who purchased them? Isn't that in the state? Is that?
No.
No,
Typically, we get it from your guys.
or the stores that sell them?
Well, that's where your guy has to go get it. Because I've given a gun back before, and then I had officers come at me just because, well, you gave the gun back to the wrong
I
person.
mean, what if this was a private sale, Judge? What if there is no documentation?
Then I probably wouldn't do it then, because I don't have proof. I'm telling you, I've had a problem before where I've given a gun back, and then the true owner came back to me and said, hey, what the hell are you doing, man? You gave my gun to someone else.
Right. Well, I mean, it's returning a firearm that was with someone when they were arrested is different than saying that person had ownership of it or purchased it or is the.
What if someone else comes and says it's their gun? What am I gonna do then?
I think that would be a issue between them and the defendant.
But they still come to me because I'm the one that granted the motion.
Well, so
I'm
if-
telling you, it's happened to me
Right,
before,
but so
so
if
can you?
someone had something, they were taken by the police and their case was dismissed and then it was returned to them, I don't.
They could have conceivably borrowed it from someone else,
Right.
So can you ask your client for something where they have the proof of purchase, and then I'll gladly grant it for you. I don't have a problem granting it for you. I just want to know that I'm giving it to the right person, because I've done it before and he was given to the wrong person.
Okay.
I just want to make sure that I'm doing the right thing. If he has the receipt or something, usually when you get something, if you buy it, you get some kind of proof of purchase.
Okay. Your Honor, if I don't know, I have not talked to him about how he purchased the gun or when, but in anticipation of that, if this is something where it was like a private to private sale with like an affidavit from the person who sold it, it'd be sufficient.
I think so.
Okay.
Because then they can be held to some kind of standard
Okay,
in the event that they're lying,
Okay.
because then it's perjurous, right? So,
okay.
but I need some kind of proof other than just, hey, it's mine.
Right.
So,
Got it,
yeah,
Judge.
okay.
And Your Honor, I'm also here for a case that Ben Friedman is on. This is
Wait,
Mr. Rollins.
just the last name.
Hinojosa.
Okay. Okay, where are we at?
So this is a PTI, BWI, the BWI PTI case, Judge. Everything's been submitted. The contract was received yesterday.
We'll give you a couple weeks to finish it out.
Thank you, Judge.
Yeah, for sure.
Thanks, sir. Thank
Of
you.
course.
Yeah.
She got a warrant? Hey, Chip. How are you, man? Hey, that Rodriguez case on Hills has a BVR.
Not for the felony. And no, that she said, they said they're filing the VDI and felonies. Yeah.
Stay there.
Hi, Mr. Hill. Good to see you. How are things? Hey, I'm live streaming, by the way, just so you know. Do you just want a normal reset?
We have a case up and running.
Sure.
So Judge Thomas and you and.
Just be careful. We're good.
Good, okay.
Just have fun. Good luck.
Good.
And
Good. In November. You don't think-
we'll see. Yeah. You too.
Yeah, I know.
Well, I think that.
I didn't check out right now.
Yeah, we.
Has a future value for catering.
Are you ready?
I'm ready and I'm ready.
Come on.
Yes, sir. Hello, we see you. Good.
Just couple one for that.
Got it.
Yeah, what about prosecutors in San Antonio? Yes or no?
No. All right, Mr. Arab, you were charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. As a condition of your bond, I'm ordering you not to participate in these types of activity again. If you reckless driving, street takeovers, donuts, anything of this nature, I will revoke your bond, put you in jail, no more PR bonds, and then I will take your ability to drive away from you if you have it now. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have both, do not drive. Do you understand? I will protect my community at all costs. If I have to put you in jail, I'm not going to lose sleep over it. Does he have a license to drive?
He does, Your Honor, it's eligible.
Do you mind filing those conditions?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Monks. If he tells me he cannot get a hold of you, if you pick up a new case, I will revoke your bond. There are no more PR bonds for you. Do you understand? You pick up, if I have to put you in jail, this is not a revolving door. You understand? Come on.
Thank you very
We
much.
need him to stay to sign conditions though.
Okay, so.
Come on.
Get the reset and talk to police.
Yeah. You're right. And no. He's for state's conditions, so he'll have to take a seat in the jury box. Once we get it and he signs it, at that point, he'll be free to go.
Right.
Wait,
Right this way. How it is.
thanks.
Yes, sir.
What you gonna use?
Let's do.
I think.
Um. All right, go ahead and send. All right, and we just have signatures.
Thank you, Victoria.
John. They are using the system. That we achieve. We have a goal across all of Brenda. That's the question.
Victoria. Victoria, you have a cause number for,
Yes.
Like, we don't have the development system.
Bottom of 19.
No, in the box.
Sorry. Yes, Judge, you have it?
I don't have it. Oh, yes.
2, 5, 8, 4, 7, 8, 9.
Yeah.
It's so hungry.
Thank you.
Hey,
I just got your email. So I looked at the report. What he tested back for was like the metabolites, which stay in your body for a couple of weeks. The active metabolites. He came back at 000. So you remember, Your Honor, I approached you like last week. We reset him for him to get drug tested on that specific day. And you said that if you test positive on that specific day, then you revoke his bond. So whatever court date we have, I forget what it was, whether it's April or May.
I'm putting him on the docket for Monday and I need to see him Monday.
That's fine,
Okay,
but
I'm not, I need to see the records. Show me everything. I'd like to see it because cocaine stays in your system for 3 days.
not the metabolite that it breaks down into.
We'll see.
Yeah. Okay, I'll bring you some research reports from them.
Great, but we'll see. We'll talk then. But he needs to be here. I'm not doing anything until he
I
gets.
just want to make sure that he's here on Monday, but I just want to come by and kind of talk to you about it a little bit.
Okay,
So, all right, thank you, Judge.
perfect.
So the report has a very red point. The active, do it and active putting on field.
We're good.
Are you ready?
I have a regular.
You mind bringing your client out?
This was an older no really. General homework in that plan.
What's the last name again? Okay, just the last name, just the last name. Got it, okay. All right, Mr. Upsall, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Are they still together or no?
No, she's in South Carolina, he's here, and then.
Got it. So
By text.
I am ordering you as a condition of your bond not to have any contact with this complaining witness whatsoever. Do you understand?
No harassing her, contact and that.
I don't know because I don't know from her whether she wants to have contact or not.
She does, because she did.
Yes, Your Honor, I've talked to her, he's not opposed to it, no record. And haven't had contact with each other. I spoke to the complainant, state would not be opposed to no threatening, no harm, she said they don't have contact anymore.
So what for then? Right? What, if they don't have contact anymore and she lives in a different state?
Still text each other. He cares for us, though, he wants nothing to do with her, and she's texting him, I just don't want this to be a bond violation, this.
But if she lives in a different state and they don't really have contact, my fear is that there's now an open case and I don't want something to happen that shouldn't happen where I have, the thing is that there's a lot of vindictive people in this life. And it's best probably not to have contact with someone when you have an open criminal case, because what you may consider threat or harassing behavior is different than what another person considers a threat or harassing behavior. If she makes any kind of allegation, it's going to go against you. You're the one that's going to end up in custody. I'm also issuing a protective order right now. You do anything that, and it's like I said, it doesn't matter what you think. I don't care what you think. I don't care what you believe. It's what the other person perceives. If they perceive it and they think it's a threat or harassing behavior and they call you out on it, you're the one's going to pick up another case of violation of protective order. That's one of the worst misdemeanor cases you can pick up. So I don't know what kind of relationship you have. Sometimes it's just better to cut your losses, especially if you've not had contact with this person in a long time and they live in another state. There's a lot riding on it. You know what I mean?
I understand.
I don't know, but it's up to you.
It's okay, Jim, we're reset this for 1 week, see if we can get this thing on.
Okay, so if you want me to do the no threatening or harassing, I'm happy to do that. I am issuing a magistrate's order for emergency protection that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, and it doesn't matter how minute it is, they will probably file a violation of a protective order. And like I said, it's one of the worst cases you can pick up. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Ross. If he tells me he cannot get a hold of you because you're ducking or dodging and not responding to his phone calls, I will issue a warrant for your arrest. Do not pick up any new cases. Do you understand?
Yes, sir.
We'll have you sign a reset. I'm going to have you take your seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. All right?
Yes, sir.
Thanks.
Okay.
I'm filing those conditions, Your Honor.
Did you want to waive PC? Jeff, did you want to waive PC?
Yes, we wait.
Yeah, okay. Counsel. Hey, yeah. Do you mind? Okay, are you ready?
I'm ready.
Okay. Do you mind bringing them up, please? Glasgow, come up.
Couldn't see him, he couldn't see me.
It's okay. Good morning, sir.
Good morning, sir.
Sir, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you a 6-month deferred. That is a type of probation that if you complete it successfully, there's no conviction on your record, but you give up nearly every right known to man, entering into this agreement, signing a contract with us, telling us that you're going to complete this. If you fail to do so, a warrant will issue. We will have a hearing and you will be facing 180 days in jail. If you pick up a new case, violate conditions, don't do your classes on time, pick up a new case, consume alcohol or illegal drugs, we issue a warrant. I'm going to put you in jail. The bond is going to be high, and then we will have a hearing. You understand? For you to complete this successfully, you must do an effective decision-making class, an 8-hour anger management class, 12 hours of community service, and no contact. Who is the complaining witness in this case? So they don't have any contact? So there's no contact. You understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it or it gets revoked. Do you understand? Do you have any questions?
No, sir.
Okay, how do you plead to the offense? Guilty or not guilty?
Guilty. Guilty, I'm sorry. Guilty.
Are you guilty? Are you sure what, I mean, okay. I'm not going to find you guilty. I will withhold that for 6 months. We will give you time to finish everything you need to do. Okay, good luck to you, sir. Thank you. Yes. Oh, yeah, no weapons, no drugs, no alcohol. Hey, Aaron, what's up, man? Of course.
I'm here, Mr. Ryan. We were
Okay.
in felony court. We're never ALR today. They made us an offer.
I thought we put it on for the next day.
Yeah, we put it on the same day. I think. How about my calendar is being on today? You on your doc?
Yeah, she's on
Okay,
today.
good.
Okay. Any headway on the upstairs?
What do you mean? I'm sorry.
Upstairs, any headway on what's going on?
She's in here. They're pushing
For what?
for prison time.
Oh, really?
They don't want to do further on. I think I may have talked them into reconsidering that. But basically, I think that what we talked about last time is if she has a lot of probation up there, we would terminate her probation down here. And I don't think that was, I don't know if that's still the court's position, but.
I mean, I think 10 days is probably pretty reasonable, you know?
I mean, she's gonna have to go in and do that. She has completed the IFP course. She's now starting like this.
There's your client right there. When, do you know
We
when?
reset to May 6th. The only thing that could change things is if something happens at the ALR today. It's a very run-of-the-mill stop.
Okay.
There's always the possibility an officer shows up and says something stupid.
What's the offer now?
Upstairs?
Yeah.
Upstairs, there is a 10-year TEC probate 5.
Oh,
I had to talk to them. Like the chief up there was like, I don't know. Like they revoked it yesterday when they looked into the case for the first time. And then when we went into that, he was like, I don't know, I'll go for probation.
have we done a new TRS?
Yes, we did one. I just got it from upstairs.
They recommended the IOP, that's why she started.
But this is after the new DWI?
Yes, you had her do a T-res immediately when we came in
Okay.
and it recommended,
So what we'll do is I guess we'll continue. Because I don't know how much faith I have in everybody. So, but I know what I want to do and I want to do it the right way. So we'll just continue it. We'll do the 10 days as a condition
Okay,
and then IOP, SOP, but the next one, if there are any more violations,
Right,
is
I understand.
residential.
yes.
So
I
just let her know.
Yeah.
So I guess let's just finish it up today so we don't keep
What do you mean
kicking
finish it
it.
up?
Oh, we signed the amended conditions.
Oh,
We'll
okay.
get everything
Okay.
done today and then you just worry about upstairs.
So
So
the
just,
conditions will be to do 10 days, and then she can just do that whenever we figure out what's going on.
well, no, I mean, we need to have a set time. I mean, it can't just hold it out forever.
Okay,
you
I just
know.
don't, my concern is I don't want her to do that before she does the plea upstairs, because then they probably won't give her credit for it. She'll have to be executed from there.
I don't know if they would give her credit anyway.
What I mean is, if she does the plea upstairs, if they went upstairs and did the plea today, and then she's gonna report April 1st to do her 10 days, that could do it for both. She could do it for the probation and her down here. Are you saying you don't want that to happen?
I don't know if they'll let that happen upstairs. I don't know, but
I understand, but
I definitely want,
you want it as a
Here.
condition of this. Okay.
there's no doubt.
And so I guess my question is, can I pick a date after the date in the, like in May? We got a recess.
Sure, okay,
Okay,
pick a day,
okay,
but we need a date today.
okay,
And then, but that's a hard, fast date.
understood.
Okay, okay, all
Thank
right,
you.
done. How much longer does she have left?
She just started.
Right, okay, good.
It's like a year.
Okay, I'm sorry. Good.
No, you're fine. I just want to share that road. Of course, I don't want to next year.
Okay, I'll send you. Did you file conditions for Opsal, right?
For which one?
Opsal?
I did not,
You did? Okay, got it. Okay,
Good morning.
hey, good morning.
I'm here on Mr. Provost, and we're gonna do a plea.
Are you ready?
I'm ready.
Okay, do you mind calling your client?
Sir?
You ready?
Yes, sir.
Do you mind calling?
Mr. Provost? Let me get it sometime. Oh, you need some, yeah, forget my phone.
Yeah.
Fired today.
Yes.
All right, good morning, Mr. Provost. Sir, you're charged with failure to identify oneself to a fugitive, failure to identify oneself to a police officer while being a fugitive from justice. That makes it a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 9 days in jail with credit for the 3 days that you've done. You need to understand that this charge will go in your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days in jail. You understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you plead guilty, you can never take this off.
Okay.
Is this what you want to do?
Yes.
How do you plead to the offense, sir? Sorry?
Sir.
I'm going to find you guilty. I'm going to follow the agreement, sentence you to it. Good luck to you, sir. Please to the clerk.
Thank you for holding here. You can see, check out downstairs. Thank you, Judge.
Good to see you, Miss Teachy. Have fun.
Thanks.
Have a great day. Good morning, Enrique. How are things? Is it under,
it's under Chavarria, Judge.
got it.
Top of five.
It was, I don't know why, I didn't come in until December, but I don't know, I think Yvonne opened it or something. Refocused on, my first day here was.
I get it, but I can't continue to, you're 210 days old.
It's a .06,
Okay.
so,
Are we delaying the inevitable? You know,
you
do you want to go ahead and set it now or?
Judge, if I could get just a chance to speak to a chief about it, that's all I can for. So
Do you have anywhere else to go?
I do.
You mind coming back in maybe like 30 minutes?
Sure.
I'll
Thanks.
send it to you.
Hey,
Judge,
I'm done.
speak to Sean.
Okay. You need, Sean,
Real quick.
come on.
Judge, I have Mr. Gudo on your docket.
Okay.
He's reviewed about PTIs and have the contract. He's just, asking if he can have some time to get some money together to pay for the DAO fee and the device. He's working overtime as a welder right now, Judge, trying to get as much money together as he can.
He's a welder and he's
Yes.
working overtime, so he's making a lot of money.
He's gonna have to pay the DAO fee, Judge, and to get the device. And so he was asking if you could give him 30 days to have everything
It's
done.
220 days old,
Yes,
man.
Judge.
And he's a welder?
Yes, Judge, he's working overtime to try to get all this.
Gudo, come up.
And he had a problem with his car, so he had to pay for a car, he's having to pay for a car repair right now, and but his license is now valid, so he'd like to drive on the program, so he'll need an interlock device in his vehicle.
Hey, I'm not gonna give him 30 days. It's 220 days. We set cases for trial at 180 days. You are now at 220. I am giving you 2 weeks to get everything done. I don't care after that time. If you're not done, I'm gonna set your case for trial and I'm going to put you to trial. No more resets after that. Do you understand?
Thank
Okay,
you, Judge.
2 weeks.
Thank you.
So, hey, it's plea or trial on that day unless the supervision order is
I
fine.
think we're gonna be able to wrap it up, Judge.
Ara? I'm gonna have to sign your documentation, so what was that? I'm gonna try to not read it. And this review issue, the same day, you do not have to appear.
Margaret, I always get together.
And you don't, you just have to tell your experiences. No, and then this is a copy of your documentation, not your. Okay, still waiting. Also. I'm wondering if you're running very good. So when you're all due,
Yeah, we can't wait until we have it. Yeah, it is our requirement.
Marcus Michael, he's required today, but I told him not to come. We have an agreement with the state to do an online course for completion. It is complete. We're now told he needs. to
So
do it.
when
We
can
already-
you defy a court order, man? You know, Mr. Gold, you're defying a court order.
I thought there was a need for him to come today, Judge. I
Great.
apologize.
But I don't care what you think. I mean, it's a court order. You cannot subvert a court order. What the hell is going on here? Really? Please don't do that again. All right? What is the offer that you've given in this case?
Sorry, Judge.
PTI,
Michael.
And then I'll.
he's completed what we need, but we need to have the contract filled out so that we can finish it up. It's
Okay,
This is something I've never asked.
how long do you want?
2 days, I can just sign it electronically.
Okay. All right, so we'll roll it. Today's what?
Can you generate a contract?
Yes.
It's not already done.
Marcus Michael.
For future reference, if you want to do something like that, talk to me before and I'm fine doing it, but don't just, you know,
Judge,
really.
I totally understand. He said to me 11 o'clock last night, he didn't have money to Uber here. I told him it shouldn't be an issue since we had everything for completion and all my other course I've been asked
Never
once to do one of these. contracts.
assume anything
Yeah.
in life because that's when you get in trouble. you know? All right, we'll see you in 2 days.
Thank you.
If it's not done, his butt better be here.
Oh, absolutely. Okay. Do you need a princess?
Carlos,
No, it's in the.
hey, bud.
We'll send it.
Oh, it's bottom of page 18. Friday, SFBF.
You have a Mr. Castillo Ramirez.
Okay.
I believe we are working on a PTI, Your Honor. I was gonna ask for maybe a week reset.
I'm okay with that.
Thank you very much.
Yeah, I mean, are you guys getting the contract? Are you guys submitting everything?
Well, I'm new to everything since, I don't know if you knew our lawyer that we had before, Lauren Winters. She moved to New York.
Okay.
So I'm having to catch up with everything, so and I'll have everything.
So you're at 165 days old, so you're getting old, right?
Yes,
I'll give you a couple weeks,
oh, that'd be great.
but if you want to do the PTI, they have to have the everything done by that time. Do they need a mitigation packet on this, or is he approved?
Believe so, Judge.
Then we'll make sure to put all that stuff together.
Please, I'll give you a couple weeks, and then good luck, Carlos.
Thank you. And one more gentleman, we have a Mr. Ellis. Mendes.
Just the last name.
I'm waiting for Mendes.
Oh, yeah, this dude's got bond violations. Right?
Yes, sir.
Or maybe. Eliezer Mendez, come up. I am literally beside myself, Carlos. I am absolutely beside myself. You're on bond for a DWI. You pick up a criminal mischief, an assault, and not even a week later now, another DWI.
Yeah, we do really want to look into it, just to see exactly what happened with that new case, but.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 23rd, 2026, in Harris County, an officer was dispatched to assist with a traffic stop for a vehicle that had ran a red light and made a wide right turn. Driver was identified as the defendant. Officer observed red, glossy eyes, slow response to questions and instructions, and a low, slow speed. Officer observed an odor of alcohol emitting from the defendant's breath or person. The defendant stated he consumed 3 Corona beers. SFSTs were conducted, 6 out of 6 HPN, 6 out of 8 walk and turn, and 4 out of 4 one leg stand. DIC was read, and a breath sample was provided. Result was 0.152.
Hey, Judge.
I have not revoked the bonds on the other cases though, correct?
Right, because I think you did on 320, Judge.
He just picked up another DWI. He's on bond for another DWI
Case you raised it to 5,001.
after he picked up the assault and mischief. This is now another new case.
That case was
5,001 indicates I've revoked that one time. He's picked up 3 cases since that time.
okay. I just remember you took them in and I see that it was 20. Should your client get the information on the things? The information does say through 23. You took them in on 320.
Some things, yeah. Before we were $30. He gave.
Yeah, she had it on the board, like this council, yes.
So I revoked his bond. He makes a new surety bond on 3/21. Right?
Yes, Judge.
2 days later, he picks up another DWI.
The conflicting dates on the court processing page, it says 3/20, so I thought that was the day.
No,
But
this is a new case. You are a complete and utter danger to our society. Look at me. You are a complete and utter danger to our society. In every fashion, there's no conditions that I can place that will ensure our public. As a result, I'm taking you into custody now, and I'm making each of your bonds $150,000. Do you understand? And if you make bond, your ass is to stay home 24 hours, 7 days a week. Look at me. Do you understand?
Yeah, we're really.
Serenity
waiting to
now.
see- To look at that new one, Judge. Yeah, and he is a very respectful, hard, young guy, so I'm sure you can see that. We'll see what we can do to deal with these other issues, y'all.
So home confinement, if he bonds out, GPS, scram monitor,
I wouldn't expect to apply that.
that's it. But, okay, that's it. All right, Carlos, he's gonna pop up on tomorrow's docket. Do you have a, did she by chance? He's gonna pop up on tomorrow's docket
Yes, sir.
as a fail safe.
Okay,
So if you want to pop in through Zoom, we can just give you whatever reset you want after that. But,
thank you.
all right. Hey, you ready? Like I cut myself shaving this morning and I'm so angry that I split my lip again.
On Mr. Ron,
No, you don't.
I just want to clarify where we're at, because when we were here last time, the intention was if we can work out the felony, you'll perm her here with like 30 days, and then she could do 10 days up there.
I want to, I'm just gonna run it at the same time
Okay.
because I want to make sure that things are done right. I don't
And I'm
want
just
to,
trying to figure out, because we weren't prepared today to pick 10 days. And she's trying to figure out like the work and childcare and all that.
I'll give you a couple days if you want.
Okay, I mean,
Sure.
yeah, I mean, if I.
Well, I mean, I don't want to railroad you. If you want a couple days to figure out what the time is. then sure.
Yeah, and do I need to put her on the docket or just come back and talk to you about it? mean, you
Well,
intend to keep her
let's
on?
set a day so that we know when you're going to come back, but we don't have to formally put on the
But I mean, is the
docket.
intention to keep her on probation?
Mhm,
It
mhm.
is, okay. Because initially you
Yeah.
said, I don't want to keep her on two different probations. I understand if you want to change your mind about that, totally up to you to do
Yeah.
that. But if we're gonna be.
I have a lot more experience with her.
Yes. no,
And I
understand.
don't know up there
I-
if they're
I-
gonna try to continue to continue to
I hear what
baby,
you're saying.
baby. I'm not,
I
so,
totally understand. We're probably gonna be working out the felony in May, on May 6th, which we just reset it to.
okay.
And so if we could,
I'm not gonna hold it till May. I mean, I want you to guys, let's finish this up. We're gonna start getting it done because I want her, the longer we delay treatment, the worse it is.
yeah, she's finished treatment. I mean, she's finished the IOP program. So she's doing. And
So
she's,
that's what we want. We
she's
want it
in
to
SO.
continue, so take up to a week.
okay, can I just like pop in on Zoom and tell you the day?
Sure.
Or does she
Yeah.
need to be here with some?
No, we
Okay.
don't need her.
Okay.
Well, no, actually, we do need her to
We
sign
do.
it.
Okay, okay,
So pick a day, whatever day you want. You can pop in through Zoom, but we need her here to sign.
okay, okay, all right, thank you.
Okay, for sure. Adnan, what's up, man?
Judge, I'm here for arraignment on Nabil Asif. He's here in the courtroom.
Do you mind bringing him up?
Top of two.
Good morning, Mr. Asif. You're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 18th, 2026, officer in Harris County observed an orange BMW and a black Mercedes slow their speeds to 20 to 25 miles an hour, then simultaneously accelerate to a high rate of speed in a racing competition. Officer had to travel 100 miles an hour to catch up and maintain a visual, all in a 65-mile-an-hour zone. Two motor vehicles continued to do this 2 more times, slowing their speed and then outpacing one another. Traffic stop was initiated. The BMW driver, the defendant, was identified by his Canadian driver's license and admitted to racing.
How fast? Did they pace
Officer
it?
traveled 100 miles an hour in pace.
Sir, I'm going to find that there's probable cause to go forward with your case. If I find that you participate in this type of activity again, I will revoke your bond and put you in jail. You understand? I don't care what kind of car you have. I don't care if you have a Lamborghini. I don't care if you have a Porsche. You participate in this racing activity again, you will go to jail, and then I will take your ability to drive away from you. Do you understand? We are going to have bond conditions created for you to sign memorializing and you promising us you're not going to participate in this activity. Once you sign it, at that point, you'll be free to go. You are not allowed to drive unless you also have liability insurance in your name. That is also a condition. Do you understand?
Yes, sir.
Okay, come on. Thanks, Adnan. Yep. So no racing and liability insurance.
Yeah.
I got you.
I have some other conditions in your page, I just do this on.
Got it. Okay. So on Mendez,
Yes.
all of them at 150,004, please. 150,004. Hey, ready? Yes. Good morning.
Good morning.
What's the last name here?
Taylor?
Okay. Oi,
Oh, it's gonna get worse, Judge.
where is your client here?
It's not.
Okay.
Council told me that she got picked up on the way, and I was able to confirm.
What do you mean she got picked up?
I don't have all the details, but she sent me a text that she got, I guess, got pulled over on the way here, and they took her in for driving on a suspended license. And I was able to confirm that she's in James.
Did we order her not to drive?
So, no, well,
Well, I mean, obviously we did because you're not supposed to drive without a
correct.
license because it's a
And- but
DWI.
It was not a bond condition. This case, just say, it was no PC at my district and they refiled it. And when I got appointed, it was outside of the 15-day window to do the AL. So, because typically I do take care of that.
Well, that's nice of you to do that. Not many do.
Give me a chance to talk to them.
Sure, but not many do,
Yeah.
you know?
Plus it's also fine. But just, she was outside that window. And so I think when she came to court, her license was good, but then, you know, the timing of that.
I guess let's see what they do. This may impact up her upstairs case as well. Who knows? You want to roll it? You want to roll till tomorrow?
Well, I think we're gonna have to, because if she's in JPC, she's gonna pop up tomorrow.
Okay, we'll do that.
So-
SFBF tomorrow. Yeah. If she bonds out, she needs to be here though.
Okay.
Okay, thanks. Good morning, Mr. Henderson.
Morning.
You ready?
Yes, sir.
Who you got? Just the last name.
Molina. M-O-L-I-N-A.
Okay,
Yes, Judge, you have PTI, recently worked out.
I know we've
Which is people ain't imagining what she did, however, she never did pay the $30. In the meantime, she now got $30, however, offer been dropped, he picked up a new felony charge.
she what?
Picked up a new felony case in between.
Council, will we start?
Melina, come up. Is this the same complaining witness?
Yes, Your Honor. I'm confirming right now.
You have now picked up a new case. We ordered you not to pick up a new case. Sorry, but you're going to jail today. We ordered you not to have any threatening or harassing contact, and you picked up a felony violation or assault stalking against the same complaining witness. Goes with you.
You open a bond and send a new bond, Judge?
Yeah, of course. I don't know. I guess we'll see. She'll pop up tomorrow. I
What
can,
you said today, we'll have to come back tomorrow and get a bond.
no, I'm gonna set a bond now,
Okay.
but we need you to come back tomorrow because she's gonna auto-populate tomorrow.
Okay.
If you want to zoom in, you can also zoom in so you don't have to physically come here if you can't make it here.
Okay.
It's your choice, whatever you want to do. Yeah, but
What's the bond amount?
10,001.
If she bonds out, I mean, if she posts a bond the day, she might be out.
If she does, that's right. She could, and then she'll get a 7-day setting
Okay.
at that point.
All right.
But if she doesn't bond out, then we do need you here.
Okay.
And I'm gonna tell you now, with this, I'm done. We're either setting up a trial or doing something, but I'm not gonna just continue to reset and reset and reset. And so you have offers.
She wants $30. She paid $30. This case will be dismissed already.
Now it's gonna cost more than $30. She's had since January to come up with the $30 and now you think,
The $2 a month.
okay, my friend.
All right.
And 10,001, I'm going. Are you ready, Mr. Gantz?
Yeah, sure.
Come on up. So what was the last name of your client again?
Martinez.
That's right.
Matt. This was the GPS. He had some work violations late from work, and then the most recent one was not work. It was work landing by him. It was Sunday. Usually it was something like time to get home. That's when he traffic. So the first violation that we addressed was work, and that's why we had extended it. But he's in the room with this, and so you know that.
So at what point do we say, come up, Mr. Martinez? Do you see how many people we put in jail? I just made someone's bond 300 and something $1,000 because they don't get it. Here we are, a second PWI, a second violation. At what point does when become when? At what point do you get the message that we mean business? I have already tried to help you with your work schedule. And here we are with yet another violation. If I let you go, what am I telling you?
That it's okay.
Correct. So you are supposed to know and anticipate these things so you don't have to come here with yet another bond violation. Let's do this. I'm going to send him for a drug and alcohol test now. We'll see how that comes out and then we'll talk. But I'm at wit's end with you, Mr. Martinez, because apparently the $20,000 bond, the second DWI, all the bond conditions we placed have not reached you yet. What is it going to take? $100,000 bond, a $200,000? You say no, but your actions say differently. When my child makes a mistake, I say, come on, buddy. I've told you once. Makes the same mistake again. I've told you again, buddy. That's twice now. You make the same mistake a third time. Buddy, I've told you, do you want me to spank you now? And now a fourth time. How many times is this with you, Mr. Martinez? One DWI, two DWIs, a bond violation, another bond violation. You get my drift. I'm sending you for a drug and alcohol test. We will go from there. But get the message, because I'm not going to have this conversation with you ever again. Do you understand me?
Yes, sir.
Sit down. No, pending results, and we'll see. Okay. If it's positive for anything, then I'll reach out to you. Other than that, we'll continue. But any further violations, there's just no tolerance going forward at all. I don't care if Mother Teresa tells him something differently. Right? Okay. All right.
I got it. What do you want me to do on this reset?
Just do a normal reset for now, pending the results, and then we'll.
Yes. Have a good day.
Admonish your client, please. Okay. I know. I got.
Thanks.
I'm sorry.
No, it's, just a thing. I would probably go come back into the. How do I receive? And I
Mr. Alton?
No. Thank you.
You're welcome. Mr. Stewart, right this way. And then it's right there. Here, just make sure you stay constant. Asa? Ask us.
Why did it sign for this? Yeah. And then this room here, next study, you can add this here, just make sure that it's pocket. And then the conditions, just make sure you would be. I don't know. That's what we think, that's both your conditions. Whether you call money for something that I'm learning. All right, there you go, you're free to go. You're welcome. Your middle okay? We don't need to I'm gonna have that now, if I can bring it as first. And then I just have to mention it that you deliver.
Oh, that's true.
And actually, the only.
But only every day, if you're not.
Yes.
Anytime something, an incident.
Hey, man. Who is it?
Was it right? 33, within 72. He's ready to turn something right now, or ready to turn something
When?
today.
Okay, sure.
Yeah. Yeah, today. I need to turn something right now, if you want. I think that thing was recording, you can fill it over there.
I don't care. But yeah, he's got to go in today. Yeah, okay. For sure.
Just need to make sure so I can.
No, for a moment. What's that?
You coming over here? No.
Okay, I've done the order.
Thank you, yes. I did have it. Also the.
Huh?
Señor Padilla, sí, usted voy a- en la luz azul.
Are you dismissing Enrique's case?
Yes, sir.
Yeah, okay. You hear that, Victoria?
Yes, Judge.
Just, we're approaching the over.
Yeah, do you need a translator?
Yes, he's right.
Here.
Hey, Luis. Mr. Padilla, you're charged with driving while intoxicated. Second offense. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they are offering you 30 days in jail with credit for the 3 days that you have done. Is this how you understand the agreement?
Yeah.
Do you know what happens on the next DWI, Mr. Padilla?
Yeah.
What happens on the next DWI?
Jail.
Wrong. Prison. 2 to 10 in the penitentiary next DWI. What did I just say?
That'll be, prison for, 10 years.
Not Scottsdale, prison in Huntsville with the murders and all the people that are in Huntsville doing life and everything else. You will be with them, perhaps if you pick up another DWI. For the rest of your life, if you want to consume any alcohol, don't get into a car because you are taking a huge risk. Do you understand? It's not hard. Take an Uber. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement today, you can never change or undo this. It will reflect as a conviction on your record forever. From now on, it is a minimum of 90 days in jail. Do you understand?
Yeah.
How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement, sentence you to it. I'm going to suspend your driver's license for 1 year. Do not drive. I will allow you to turn yourself in by 6 p.m. today. If you fail to turn yourself in, or if you go late and they don't take you, you will be facing the full range of punishment, which is an entire year in jail.
Yes.
Okay, good luck to you, sir. Thanks, and you can waive it.
Okay. But that was not what I-
Okay.
Look at you. No manches. Hi, Diana. What's up?
A case that I'd like to do a walkthrough on.
What's your cost number, please?
Do you have the cause number?
Yeah, it just said John's.
I have it.
Okay.
Give it to me,
It
please.
is 257-5702.
Okay. Do you mind bringing him up?
Did you file an attorney of record on this one? McDonald? Did you
Yes.
file the attorney of record when you said?
I'm filing right now.
I have one in the thing, if you don't mind filing it,
Yeah,
before you leave.
yeah, I'll file it right now, yeah.
Got it. Mr. McDonald, you are charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 28th, 2025, officer in Harris County observed the vehicle with the driver texting on a mobile device while driving. Officers ran the plate and noted that the owner, the defendant, had 6 outstanding Class C warrants. Officers observed the defendant as the driver and conducted a traffic stop and arrested the defendant on the warrants. A handgun, as well as 3.77 grams of marijuana were found in the vehicle.
Okay. Does he have a license to drive?
Let me run a check.
What'd you have?
Did you get the cause number there? It's 257-5702. Mr. McDonald, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to be in possession of any weapons while this case is open. If you do, if you violate conditions, if you pick up a new case, I will revoke your bond, put you in jail. I'm going to reinstate your bond today. This is the only get out of jail free card that you're going to get. I'm not going to give you another one. If you continue to miss court, if you fail to stay in contact, you pick up a new case, I'm just going to put you in jail. And do you understand?
Yes, Your Honor. It's not eligible.
You are not allowed to drive. You do not have a valid Texas driver license. That is also a condition of your bond. I don't give a rat's behind what you have to do in this life. If you don't have a license and liability insurance in your name, do not drive. I'm telling you now, I don't think there's anything that makes me more upset. You get into an accident and there's a problem. The other people are high and dry. It's just not fair. Do you understand? Do not drive. You're going to be signing an affidavit with me today. This is a promise you're making to me that you're not going to drive. I don't care that you have to go to school. I don't care that you have to go to work. I don't care that Mother Teresa needs to ride to church. I don't care that a baby has to go to the hospital. You cannot justify driving for any reason. If you want to drive, go get your license, get insurance, and I will happily take this restriction off. But until that point, you do. You understand? Okay. Because you have a lawyer now, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games, likewise, the bond gets revoked. I'm not asking much from you, man. I just want you to follow the law. That's it. Do you understand?
Yes, Your Honor.
Okay. We're going to have you come up here, swear to us that you're not going to drive. I will get you to sign a reset. We're going to have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Okay? All right. Thanks.
Thank you very
Yes,
much,
ma'am.
Ryan.
You too. Take care.
How long ago was that?
Just a normal one. Yeah. I mean, she's just not signing on for the first time, so. it's-
Good morning.
Hi.
How are you?
Good morning.
Judge, I'm here on Francisco Martinez.
Okay.
Judge, he's been offered, or he was offered a street racing kills course online.
We've given him time and time and time, and you're now at 200 days. Where's Mr. Martinez now?
So he's at work. He sent me.
I'm revoking his bond. Oh, did he get it done?
Well, he registered to take it tomorrow. He said.
I'm revoking his bond.
Oh.
He's had, it's to no. He's supposed to be here. He chose to go to work. He didn't get the class done. It's 200 days old. I'm revoking his bond, Yasha.
Judge, I told him all this, but he said that I can show him, he works for Chevron and the oil rigs like out of state. He sent me proof of that. And also, he sent me
If
proof that
he-
he's scheduled to take a class tomorrow.
I don't
So- And I
care.
told him,
Yasha,
he needs to be here. I told him that.
I'm revoking his bond. If he gets the class done and he gets it to them and they dismiss it, that kills the warrant. But I'm tired of babying people.
Right.
I've given him over and over and over the reset to get it done. He failed to come. He chose to go to work. He knew he had to be here.
Right.
If I don't, what's gonna happen? We're gonna set it another week and it's not gonna get done. No, that's
Sure,
it.
he promised he's gonna get it done tomorrow. You can set it for bond forfeiture.
I'm not gonna do that.
You know?
No, he was supposed to be here today, didn't get it done. I have to hold him accountable.
Yeah, he's scheduled
Maybe now
tomorrow.
he'll realize that we mean business. Stop screwing around. So I'm setting it at 5,001. Tell him he needs to get the class done. And then that'll make the case go away.
Okay, Judge. All right.
All right, yes.
Thanks.
All right, buddy.
I'm fine, I was in the jury box for your bond. And that's it, I can we file with
I've got. Make sure she files this.
Diana, did you get the attorney?
Great. Hey, we're ready for him to sign here too.
Okay. Thank you. They're in the queue. Oh, you're here for me or, I'm fine here.
Conditions ready for Mr. McDonald to sign.
Perfect.
Hey,
Hey, Judge, how are you?
hey Hector, what's up, man?
Judge, I'm here tomorrow on Arturo Ortiz. Judge, Mr. Ortiz, I spoke with him saying, heck, I have purchased a mouthwash that doesn't have.
I
alcohol.
admonished these,
I get it.
come up, you. I admonished you to the tooth last time you were here, over and over. And the one thing that I did not want you to do is this exact thing. You now are going into custody.
She was gonna swear this morning, Your Honor. I don't know if that would help.
Oh, it's up to you,
I've explained to him, good, because I told him, you know, in this situation, judge is gonna have you under his thumb, even more so because of the violation. I said, I went to spoke with Rick this morning, and Judge, it does look like the way that the alcohol was basically doing, that there was a huge jump after the second test, which is more indicative of what he told me. Judge, it's up to you, but I'm.
no, he's not supposed to have anything. You're on bond for 2 cases, and I warned you. You knew everything that you're supposed to put in your body, you're supposed to look. I don't care how low, it's supposed to be none. If you want to work something out,
No, we do.
I don't care, but I mean, I can't just, it's bond violation after bond violation. Okay,
That's it.
for sure.
That's a little.
I just hold on, because it looks like they're gonna try to work it out, but it would be. Ramona. You ready? He's in Zoom. Yeah. Hey, JP, are you ready? Are you ready?
That client's going on, there.
So this is my view?
Like, can I?
We were supposed to have Luis. Not that you're not good enough, but I think that we were gonna have, like, we were gonna work, because you can't do both. You can't be here working in the. That's what I was, so that's what we had scheduled, the specific, just for the hearing.
Yeah, so
Is
he-
separate and apart.
He's working PC critically, he asked me to come for a hearing instead.
Okay.
And, well, I was asking is because we could do, like, if he has a phone, I could just call him, interpret on the phone simultaneously while the hearing is ongoing.
He's in Mexico. So that's the problem is I don't know what kind of,
Well, I could.
it's not
I
like
could
it's a
do,
local call, you know?
So we have to do consecutive. Hearings.
But he's, I mean, if you're not here specifically for the hearing, it's
No,
something.
yeah. I mean, that's really, that's not me that, for the hearing.
Okay,
Can you hear him?
what do you think?
What's the issue, Doug? Madam?
Yeah, of course,
What's the issue, Doug?
translating.
Well,
I mean, we'd have to have it could just completely quiet and kick everybody out, so.
Yeah, just, all right.
Or can you hear
Can you
him?
call through your phone?
Do what's that?
Oh, yes.
Oh, what's that? We can do that. Because that's not in that copy. If you wanted to go more.
Yeah, let's do that.
Yeah.
Yeah. However you think.
I can interpret well, hearings ongoing.
The executive, easier to do it that way?
Well, unless, because otherwise we'd have to do consecutive, so we have to stop and pause and kind of interpret as it's going, as opposed to just the whole time you guys. Is he gonna be testifying?
He's here via Zoom.
No, I know, is he gonna be testifying?
Yes.
Yes,
Okay. I mean, is that gonna be?
it's probably easier to do it
I
that
guess we
way.
can try it that way, does it? Yeah, let me get my phone and give you the WhatsApp.
Yeah.
Okay. So, yeah, I mean, JP, why don't you call him via WhatsApp and then he's gonna have to mute himself here so that, because then there's gonna be a ringing.
Until he testifies.
So he needs his audio and mic so that we can just hear.
Hey, Cynthia, you want to talk to him?
Just wanted to ask. I have a client.
What will they do? Will you get your
That
dimensions?
was about felony. He was in probation and he escaped and picked up the new conviction today.
Okay.
And I don't know how you do it, but I asked her, we were checking with you, do you make a decision? It's MAJ. He got 180 days state jail on the felonies.
What's the last name?
Guzman,
What's the last name?
Guzman, G-Z-M-A-N. He was the one that mother is in prison for capital murder. You were really trying to help them get this.
What you hear?
What,
So as long as my.
he got 180-day state jail?
Yeah, he escaped from.
Right, I remember.
Yeah, and then he got a drug case, they dismissed the drug case, and then he let him on this escape. And the lawyer tried to get him to do an experiment.
I'm leading through then.
Yeah, it's,
Okay.
So
I will try to back to Arkansas.
I've been tracking just to see what was going on in felony and at the last time he had.
just, I guess, unset him, so we can just get you done, you know.
Thank you, George.
So suspend the license for a year because we didn't have it suspended before because he's on probation. And then, I mean, he had already pled guilty to it, right? He's on probation, it's not like, it's not a deferred, is it?
No, it was a.
Yeah, okay, yeah, so there's all for all intents and purposes, it's whether we unsat term him or whether he comes out and pleads guilty, it's all the same regardless. So just unsat term to make it, so you could just go and do
Okay, so
it.
she
Yeah,
has to file a motion to dismiss.
sure, right.
Also,
right.
it's not necessary.
Yeah.
I just
Yeah,
wanna make
we're
it-
with you. We'll just give credit for whatever it is. Thank you, Ms. Henley.
Hey, Judge, when it's happening at this, also not testify. When can't he just testify from?
I mean, hey, look, the problem is that if you talk to him on the phone, he's testifying to you on the phone and we're not going to be able to hear it. So probably the best way is just so that everybody can hear it, just in case. He'll just have to testify here and you'll have to translate it.
Yeah.
And we'll just do sentence after sentence after sentence, It's not going to be that long anyways.
Right.
It's going to be maybe 5-10 minutes at the most.
Yeah, I think it should have.
All right, then. What kind of hearing is it?
It's a writ. A writ to reopen the BI.
Let me try to explain to him. Give me 1 second if I could.
Yeah, so JP, we'll just have him testify here and then he'll just,
I think that'll be easy, and I'll keep it short, because we're not gonna.
Yeah.
We can do
what is your name, sir? Last name?
I'm here, you're on case.
Oh, okay. What is your name, last name?
Right.
Wait, Adam, Adam signing on, remember the solution stuff? From yesterday, the last video? I emailed Adam to come back.
I'm gonna speak to Mr. Doherty and I'll head back. Let's do my job, we had disappeared.
You know that from them saying.
So now, okay, she left. She gone. Veronica? Oh, her stuff's gone.
No, because we're going on whatever cheese.
We need to do conditions on a portable device.
Okay.
Have you reached out to our MAC attorney to say that Ms. Breedy's not been here for the last like 3 days, 4 days, and people come here and Breedy, her lawyer,
Oh.
and maybe we just can't get her. Oh, and we're about to go on the record. Do you need anything?
I'm gonna have a plea ready in just a minute, Judge. You want me to come back after your hearing's done?
I don't think it's going to be very long, but where's your client now?
Miss Black is from. That must be the royal side.
Yeah,
He's
let's get this hearing done because I don't want to, I mean, everybody's ready to go. And your client's not here, so. Ramona, you ready?
Give me half a second, Judge.
Ah,
I'll get it done.
it's okay. Ramona.
Yes, Judge, I'm ready.
Okay, there we go. Okay, everybody ready?
Yes, Judge, can I just see if my client can get and respond?
Barrientos, can you hear me?
Yes.
¿Me escuchan bien?
I'm gonna need you closer.
Thank you. That's a little strange setup.
When you start speaking, I'm gonna need you to, so he can hear you. The microphone is right here. So you're probably gonna just have to, sorry, hang, so he can hear.
¿Me puede escuchar de acá?
Sí.
Actually, the microphone's that's the microphone right there.
Do you mind, Judge, when I question?
No, and both of you guys, so that, you know, please. All right, so here we go. We are on the record in cause number 2580504. It is, this is a writ of habeas corpus. Today's date is March 26, 2026. It's approximately 10:51 in the morning. It is Oscar Cruz Barrientos has filed a writ of habeas corpus. Guys, would you please announce yourselves for purposes of the record? State starting.
My name is Emily Thompson for the state.
John Paul Cedillo, Cedillo for the applicant.
Estamos en el acta, se ha presentado.
Judge, can you have him come forward a little bit?
I don't know if she can translate. Can you type
Oh, wait,
in Spanish?
is that Luis speaking Spanish?
It is.
Okay, I'm sorry. Go ahead.
Estamos en el acta, en el número de caso 2580504. Desde el 26 de marzo de 2026, aproximadamente a las 10:51 de la mañana, se ha presentado un escrito de habeas corpus. Y si se puede presentar la fiscal Emily Thompson y el abogado de defensa Jean-Paul Cedillo.
Are you Oscar Barrientos Cruz?
¿Usted es Oscar Barrientos Cruz?
Sí. Yes.
Would you please raise your right hand?
¿Puede levantar la mano derecha, por favor?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
¿Jura decir la verdad, toda la verdad y nada más que la verdad ante Dios?
Sí.
Let the record reflect that for purposes of the record, we are having this hearing via Zoom because the defendant is currently in Mexico at this time. Also, for purposes of the record, when he swore, he had his right hand up. The proceeding is being live streamed also on TV in the courtroom so that everybody here can also see what is transpiring with Mr. Barrientos in Mexico at this time. So everybody can see what's going on with him as well.
Para el acta, para los propósitos del acta, esta audiencia está siendo hecha por Zoom porque el señor Barrientos está ahorita en México. Para los propósitos del acta también, cuando por un momento tenía la mano derecha levantada, también está siendo mostrada en internet y entonces aquí todos podríamos observar también de que lo que está sucediendo mientras él está en México.
I didn't realize that you were going to translate everything else. Otherwise, it wouldn't have been as long-winded. Okay. It's your writ, Mr. Cedillo.
Yes, Judge. This applicant calls Oscar Barrientos to the stand.
Llamamos al señor Oscar Barrientos al estrado.
May I proceed, Your Honor?
Please.
¿Puedo proceder, señora, por favor?
Oscar, I'm going to ask you some questions.
Oscar, le voy a hacer algunas preguntas.
If you ever can't hear me or you don't understand, just let me know, okay?
Si no me puede escuchar o no entiende, déjeme saber, ¿ok?
Can you see me okay?
¿Me puede ver bien?
No, I don't have the front camera
Okay,
showing.
I understand. There's no camera. Can you hear me okay?
Okay, entiendo, no hay cámara. ¿Me puede escuchar bien?
Se oye como distorsionado.
It sounds distorted.
Okay, I'll try to speak loudly and clearly.
Voy a tratar de hablar fuertemente y claramente.
Okay.
Okay.
Okay, Oscar, I want to talk to you about an arrest that occurred in 1986 in Houston, Texas. Do you have a good memory of that arrest?
Vamos a hablar acerca de un arresto, Oscar, que sucedió en 1986 en Houston, Texas. ¿Tiene una buena memoria de ese incidente?
Sí, sí, pues cuando me llevaron a la corte, la primera vez me dijeron que si tenía abogado, y yo les dije que no. Digo, bueno, otra vez vienes, si no traes abogado, te vamos a poner uno de la corte.
One second, Oscar.
Yes, because when I was arrested and taken to court, I was asked if I had a lawyer. I told them no. They said that I would get a court-appointed attorney then.
Okay, we're gonna go through that in detail. So let's just answer the question that I asked, okay, Oscar?
Vamos a repasar eso en detalle, entonces solo responda a lo que yo le pregunte, ¿ok, Oscar?
Okay.
Okay.
Okay, how many times do you remember going to court on that case?
¿Cuántas veces recuerda ir al tribunal en ese caso?
2.
2.
Okay, the first time, was that close to the time you were arrested?
La primera vez, esa ocasión fue una fecha cerca de cuando fue arrestado.
No, no le escuché. Dígamela de vuelta, por favor.
Could you repeat that, please?
The first time you went to court, was it a few days after you were arrested?
La primera vez que fue a corte, fue unos días después de que fue arrestado.
Sí.
Yes.
Okay, what, if anything, were you told about an attorney when you went to court that first time?
¿Qué le dijeron, si le dijeron algo acerca de su abogado la primera vez que fue a corte?
Me dijeron que tenía que tener un abogado, que porque no me podían acusar sin abogado.
They told me that I had to have a lawyer because I couldn't be accused without a lawyer.
Who told you this?
¿Quién le dijo eso?
El juez.
The judge.
Okay, and then they reset the case.
Okay, y luego le adelantaron el caso, la cita.
Sí, me dieron la siguiente corte.
Yes, they gave me the next date.
Okay. Did you make any effort to hire an attorney?
¿Hizo algún esfuerzo para contratar un abogado?
Sí, el problema es que en ese tiempo el trabajo estaba muy despacio y yo le dije, la segunda vez que fui, me dijo, no necesitas abogado, como quiera nomás te voy a poner una multa y ya te vas. Le dije, pero no tengo dinero. Dice, no, el dinero si quieres te voy a dar tiempo para que lo pagues y ya nomás vas a pagar ese dinero y ya te vas.
Oscar, the interpreter's writing down everything you say, so please speak just a few sentences at a time, please.
O sea, el intérprete está apuntando o anotando lo que usted está diciendo, entonces diga solamente una porción o oración a la vez.
Okay.
Okay.
Can you repeat what you said?
¿Puede repetir lo que dijo?
Sí, que la segunda vez que fui a corte me dijo el juez que si tenía abogado, le dije que no tenía porque no estaba trabajando.
The second time I went to court, the judge asked me if I had an attorney. I said no, I don't have any money. There's little work.
Okay, and then what were you told about an attorney at that point?
¿Y qué le dijo entonces acerca de su abogado en ese punto, en ese entonces?
En ese entonces me dijo el juez que supuestamente él me iba a poner uno de los de la corte.
I was told by the judge that supposedly he would assign someone from the court to me.
Were you ever assigned an appointed attorney?
¿Y le fue asignado un abogado de oficio?
No.
No.
Y al último me dijo el juez que no necesitaba abogado, que nomás me iba a poner una multa.
At the end, the judge said that I didn't need a lawyer anymore, that he would just be giving me a fine.
Were you ever told by the judge about your right to an attorney if you can't afford one?
¿Le informaron acerca de su derecho de tener un abogado si no puede pagar por su propio, de ser asignado a uno de oficio?
Pues, supuestamente el juez me iba a poner un abogado de los de oficio, pero al último me dijo que no necesitaba, que porque él nomás me iba a poner una multa. Le dije, pero yo no tengo dinero para pagar. Digo, bueno, te voy a dar tiempo para que lo pagues. Ya fue todo lo que me dijo, ya fue todo lo que me dijo el juez. Ya de ahí me dijo, te voy a dar.
One moment.
Un momento. Supposedly I was supposed to get assigned a court-appointed attorney, but then the judge said I didn't need one and he would be applying a fine. I told him I don't have any money and he said I would get time to pay.
If the court had offered you counsel, would you, court-appointed attorney, would you have taken that?
Si la corte le hubiera ofrecido un abogado de oficio, ¿usted hubiera aceptado?
Pues sí, sí, para no haber tenido problemas, pero nunca me dijo, o sea, el juez me dijo que no necesitaba, que nomás me iba a poner una multa y que si no tenía dinero, él me iba a dar tiempo para pagarlo. Y ya fue todo lo que me dijeron. Ya nomás pagué la multa y ya fue todo.
Yeah, well, yes, to avoid any kind of problem, but the hearer said that it said that he would apply a fine. I mean, and even if I didn't have money, that I would get time to pay.
Okay, Oscar, please speak slowly for our interpreter if you can.
Por favor, hable lentamente para la intérprete, por favor.
My next question is, did you ever personally speak to the district attorney about this case?
Mi siguiente pregunta es que si usted habló alguna vez directamente con los fiscales acerca de este caso.
El único que me fue fue el juez. No me recuerdo del fiscal, ¿para qué le voy a acordar?
The only one was the judge. I can't really remember the I won't lie.
Okay, and so before you took the plea in this case, before you pled guilty, am I right that the judge told you you didn't need a lawyer? He didn't explain to you that you had a right to an attorney if you couldn't afford one?
Antes de que aceptara el acuerdo, antes de que se declarara culpable, el juez no le dijo de que necesitaba un abogado o que tenía el derecho de tener uno.
Supuestamente me iban a poner uno de la corte, pero ya al último me dijo el juez que no necesitaba nada. Nomás me dijo, te voy a dar nomás una multa.
The interpreter needs
Can you repeat that answer a little slower, Oscar?
¿Puede repetir esa respuesta un poco más despacio, Oscar?
El juez me dijo que no necesitaba abogado, porque supuestamente ellos me iban a poner abogado. Dijo, no necesitas abogado, lo que vas a pagar nomás va a ser una multa y te voy a dar tiempo para que lo pagues. Si no tienes el tiempo, en el tiempo que te doy, si no tienes todavía para pagarlo, puedes venir a la corte y te doy más tiempo para que lo pagues, pero fue todo lo que me dijeron.
Okay, so the judge said that they were supposedly going to assign a court-appointed attorney, but then he said I didn't need one. He said I didn't need one, that I would get assigned a fine. If I needed time to pay, I would get time. If I don't have enough by the time I have to, then they can give me more time to pay.
We're gonna pass the witness. Oscar, the state is gonna ask you some questions. Please answer as openly and honestly as you've answered my questions.
Vamos a pasar al testigo. Oscar, el Estado ahora le va a hacer preguntas, por favor responda honestamente y como lo ha hecho conmigo.
Pass the witness, Judge.
Paso al testigo, pues. Okay.
Hello, my name is Emily Thompson, and I'm going to ask you some questions. I represent the state.
Hola, mi nombre es Emily Thompson. Le voy a hacer algunas preguntas y yo represento al Estado.
When you came to court, did you take any notes of what happened in court?
Cuando usted vino a corte, ¿usted tomó notas de lo que sucedió en la corte?
No, no, digo porque nomás la corte mía no duró ni 10 minutos.
No,
Nomás
the court that I had only lasted like 10 minutes.
So whenever you pleaded guilty, you were in court for 10 minutes that day?
Cuando usted se declaró culpable, ¿usted solamente estuvo en corte como 10 minutos ese día?
no me declaré ni culpable ni nada porque el juez, no te digo, como te dije, nomás me dijo, tú, Óscar Barrientos, ¿traes abogado? No, ok, tú nomás vas a pagar la multa y ya fue todo lo que me dijo. No me dijo una otra cosa más y ya luego me sacaron de corte.
Okay. No, I mean, I didn't plead guilty to anything. When I got there, they asked me if I had a lawyer. I said no. They said, well, you'll pay a fine, and then they kicked me out of the court.
So do you remember one of the days where you came to court that you gave them your thumbprint?
¿Recuerda usted que uno de los días de que se presentó a corte, usted dio su huella digital del pulgar?
No.
No.
So the information you're testifying about today is based solely on your memory and not any type of notes from that time.
La información que está dando ahorita, el testimonio, es solamente de su memoria, no está refiriéndose a alguna notas de ese entonces.
No hicimos notas, no te digo que no me dio tiempo de nada. El juez ya nomás me dijo, yo me presenté, ustedes quedaron, sí, ok, abogado no. Y digo, está bueno, no necesitas abogado, te iba a poner uno en la corte, pero no necesitas nada en la corte. Digo, de aquí, ya nomás me dijo, tienes 30 días para pagar, si no pagas, vienes conmigo.
¡Más despacio!
Ok.
Oh. No, I didn't have time for anything. I just came. The judge said, "You have an attorney?" I said, "No." Well, you don't need one.
Did you sign any plea paperwork whenever you came to court?
¿Usted firmó documentos de un acuerdo cuando usted vino a corte?
Sí.
Yes.
And I know you said you don't remember the DA, but before signing the papers, did you talk to someone about the plea from the state?
Yo sé que usted mencionó que no recuerda al fiscal, pero antes de firmar el acuerdo, ¿usted habló con alguien acerca del acuerdo?
No me acuerdo, ¿para qué te voy a decir? Pero casi nomás el que me habló fue el señor juez.
I can't remember, I won't lie, but the only person that spoke to me was the judge.
So you don't recall any talking about getting the enhancement removed as part of your plea?
Entonces no recuerda, por ejemplo, hablar de haber quitado el aumento en el acuerdo de la ofensa.
No me acuerdo, ¿para qué te voy a decir?
I don't remember.
So we do have your thumbprint from that day you pled guilty.
I think we're gonna object to that. I don't think that that's, that we can take that as fact. So assume fact's not an evidence, because I think we've all seen that smudge, and I don't know that we can say that that's, in fact, my client's thumbprint.
May I respond, Joanne? We have a thumbprint that occurred on a judgment that has his name on it. And he's admitting that he was here and talked to the court on this day. And then in 2006, Fort Bend used this judgment to have an enhanced DWI third. And although I have not spoken to them, I would hope that that thumbprint was confirmed with them. Even though he doesn't recall a thumbprint, there is nothing they have shown to
He
overcome.
pled, did he plead to that case
What, which one?
in Fort Bend?
Yes, Judge.
So it's assumed,
Yes, Judge.
overruled.
You said you do not recall giving your thumbprint, but we do have your thumbprint from when you were in court to plead guilty. And you're saying that you have no memory of it.
Sé que usted dice de que no recuerda haber dado su huella del pulgar derecho, pero nosotros tenemos una huella del pulgar derecho en el caso al que se declaró culpable. ¿Usted está diciendo que no se recuerda de eso?
No, ¿para qué te voy a decir? No me recuerdo de eso.
Perdón. The interpreter requires a repetition request.
Ask him, ask him.
¿Puede repetir lo que dijo que no le escuché?
Que no me recuerdo de eso, de la huella.
I don't remember that.
No me recuerdo, me parece que nomás que firmé.
I just remember that I signed.
Did you read what you were signing?
¿Usted leyó lo que estaba firmando?
No,
No.
Did anyone force you to sign it?
¿Alguien lo forzó a firmarlo?
no, pues más me dijo el juez que firmara, era todo lo que me iba a dar, ya era todo.
No, but just the judge told me to sign it, and that's the only thing he said.
Did anyone?
I'm sorry. Repeat that last part. Just the,
No, but the judge asked me to sign it. That's the only thing he said.
Did anyone threaten you to sign the papers?
¿Alguien lo amenazó para que usted firme los documentos?
¿Cómo dices? Disculpa.
What was that, sorry?
Did anyone threaten you for you to sign the papers?
¿Alguien lo amenazó para que usted firmara estos documentos?
El juez me dijo nomás que firmara los documentos y era todo y ya que me fuera.
The judge just told me to sign the documents and that was it, and to leave.
And whenever the judge asked you questions in court, did you answer his questions?
Cuando el juez le hizo preguntas en corte, ¿usted respondió esas preguntas?
Mira, la segunda vez que fui a corte, lo único que me dijo el juez que no iba a necesitar abogado porque lo que me iba a dar era una multa y que me iba a dar tiempo para pagar. Ya nomás dijo, firmas, ya te puedes ir.
Look, the second time that I went to court, the only thing said by the judge was to sign that I don't need an attorney and that he would give me a fine and then time to pay. So to sign and then leave.
Did you tell the judge that you were confused?
¿Usted le dijo al juez de que estaba confundido?
Es que en ese tiempo nomás me dijo firmas y ya te puedes ir. No, yo no me estaba muy joven, no me acuerdo exactamente.
At that time, he told me to sign and then that I could leave. I was very young. I don't remember too well.
Did you ask him for more time so that you could understand what was going on?
¿Usted le pidió por más tiempo para que usted pueda entender mejor lo que estaba sucediendo?
No, yo nomás firmé y ya me fui.
No, I just signed and then left.
Do you recall that 3 years later, in 1989, you pled guilty to another DWI?
We object to relevance on this one, Judge.
May I respond?
Sure.
The relevance is to show that in that DWI, he had an attorney, he pled guilty, and it went, I would assume the way it was supposed to. So he was on notice 3 years later of the proper process, but at that time did not decide to file a writ to complain of the fact that he did not waive counsel the first time.
Okay. Overruled.
Do you recall that 3 years after you pleaded guilty in the first case, that you pleaded guilty to DWI in 1989?
Usted recuerda que 3 años después de ese primer caso, usted se declaró culpable en 1989?
Parece que sí.
I think, yes.
And in that plea, you did have an attorney, correct?
Y en ese caso, usted sí tenía un abogado, ¿correcto?
Parece que sí.
It seems so, yes.
And I'm sorry, go ahead.
¿Qué dice?
En ese tiempo sí ya estaba trabajando.
At that time, I was working.
And so whenever you pleaded guilty with an attorney, you were able to see how a plea can go when you have an attorney, correct?
En ese caso, cuando se declaró, cuando ya con un abogado se pudo ver cómo el proceso es correctamente, ¿verdad?
Sí, pues el proceso ya lo llevaba el abogado, yo nomás me decía el abogado, fírmale aquí y es todo.
Well, the attorney was the one leading that. I mean, he just asked me to sign, and that was it.
And do you recall that in 1989, you pleaded guilty to DWI second offender?
Y recuerdo que en el 1989 usted se declaró culpable de manejar mientras intoxicado como segundo incidente.
Sí.
Yes.
So at that time, did you not realize that you had pleaded guilty to a DWI in the past?
Entonces, en ese momento, en ese entonces, ¿no realizó usted de que se estaba declarando, no realizó de que tenía un caso de manejar mientras intoxicado en el pasado?
No me acuerdo.
I don't remember.
Did you ask your attorney at that time why you were pleading to DWI second if your understanding was you never pled guilty to a DWI in the first place?
Usted le preguntó a su abogado que por qué estaba haciendo un acuerdo como segundo incidente si nunca se declaró culpable para empezar, iniciar el documento.
¿El del 89?
The one from the 89?
Yes.
Sí.
El del 89 el abogado era el que llevaba todo el caso. El caso ya nomás me decía, fírmale, y yo firmaba. Y no me decía, te van a dar esto, vas a hacer probation, vas a hacer esto, y ya nomás firmaba.
In the 89 one, the attorney led everything. He would just ask me to sign, tell me you're going to get this, you're going to get probation, and then to sign here.
Did you tell your attorney that in the 1986 case, you didn't have an attorney, but you had wanted one?
Usted le dijo a su abogado de que en el caso del 1986 usted no tuvo un abogado y que quería uno o que quiso uno.
No.
No.
After pleading guilty in 1989, did you file any type of document claiming that the 1986 case was involuntary?
En el caso de 1989, después de que se declaró culpable, ¿usted presentó algún tipo de documento reclamando que en el caso de 1986 usted hizo la declaración involuntariamente?
Parece que sí.
It's, I think yes.
Did you have an attorney to help you with that?
¿Tuvo un abogado para ayudarle con eso?
Sí.
Yes.
Do you know what the outcome was of filing documents stating that the 1986 plea was involuntary?
¿Sabe cuál fue el resultado de meter esos documentos diciendo de que la declaración de 1986 fue involuntario?
Pues fíjate que ya no me acuerdo, porque te voy a decir.
I mean, I don't remember. I couldn't say.
So you have a memory of what the judge said in 1986, but you don't have a memory of giving your fingerprint or ever talking to the DA, correct?
Sí tiene una memoria de lo que le dijo el juez en 1986, pero no recuerda haber dado la huella del pulgar o de haber hablado con el fiscal.
No me acuerdo, ¿para qué te voy a decir? Del fiscal no me acuerdo.
I don't remember. I don't remember what the DA.
Pass the witness, Your Honor.
Pasó el testigo.
Nothing further from this witness, Judge.
I have one question.
Yes.
Nada más, tengo una pregunta.
The felony DWI was in what year?
I believe it was in 2006, Judge.
And he had a lawyer in that case.
Correct, Judge. Yes.
And the felony, the pleadings had this DWI and that one?
That's right.
Are there any other DWIs other than that, those two, and then this one in Fort Bend?
Any other existing or any other for that?
At all, any other DWIs?
I believe there was another one that I saw, but I don't know the disposition of that one because these ones used to enhance that felony are the only ones I focused on.
Do you know, Emily?
I made a note months ago, so I would need to look it up again when I check his criminal history. In 92, I have a DWI where he did 24 months probation, but the agency was supervision and corrections. And I don't know what that, like, it isn't clear that it was Harris County or what county it was. I could re-look it up to confirm, but I do have something that shows from 92 that there was a DWI where he got 24 months probation.
So 86, 89, 92, and then 2006.
That's what I have.
That's right. Judge.
Okay, all right. Argument, I guess.
Right.
Okay, you want to tell him thank you that he's done testifying? He's welcome to stay and listen if he wants.
Gracias, eso sería todo por el testimonio. Si quiere se puede quedar para escuchar.
Okay.
Can we tell them to mute just in case?
I'll mute him.
Thank you, Judge.
Okay.
May I respond or may
Sure.
please the court? Judge, I'm gonna go through the areas of law I think that are important. I know the court has gotten the information from the witness. I think Your Honor knows the basic argument here, but I'm gonna try to hit the highlights. First, the reason this is important is because in 1986, this man who's, all due respect, advanced in age, was a young man. He was new to this country. He did not have a lot of job, money or means to afford an attorney. He was put in front of a judge on a DWI in this court, Court 5. I don't know if it was in this building, but in this court. And what he just described was basically a judge who was not concerned with his rights to counsel. He was told at first he qualified for an attorney. He came back to the court a second time, and the judge fulfilled the function of prosecutor, didn't guard his rights, and did not appoint him a counsel or inquire about his needs through counsel, as was already the law of the land in 1963 in Gideon v. Wainwright. So even though this happened a long time ago, he had a right to counsel. He was indigent. There should have been an inquiry done. That was completely eroded. If what he says is true, Judge, this is a constitutional abomination of a plea. Your Honor, no judge in this building would ever tell a defendant, you don't need an attorney. This is just a fine. just, sign the paperwork, everything will be cool. If that's true, Judge, if this is a constitutional abomination, then the habeas gives your honor the ability to cure it, even though this happened many, many years ago, even though there's some file retention issues, which we'll mention. I know your honor is a big picture person. I know you, from the last time we talked about this case, Judge, I know you're looking at some other issues in the case, like lashes, and we'll address that in a second. But if I just focus on what happened that day, if we can agree from there, if what he's telling is true, if he's credible as a witness, Judge, he came in front of the judge, he had a right to an attorney because he was indigent. Gideon V. Wainwright, gave him that right in '63. There was no inquiry done. He was rushed into a plea, he signed some paperwork, and he was told to leave. That should not stand. That shouldn't stand now, and it should have stood in 1986. But that's what my client just testified happened. And the state's only real evidence to suggest otherwise, I think it's clear he wasn't given an attorney. Their only argument for that's okay is because he somehow waived his right voluntarily or knowingly. And I'll say two things on that. One is the only evidence of that is the checkbox that is on the plea paperwork. There's no signed waivers, slip in court like how we have today, laying out his rights so that he could read and at least Your Honor could rely on. Well, they put a document in front of him and he knowingly waived and signed his rights. You don't have that. There's just a checkbox, which I think might not indicate anything. There's no description of a colloquy. This witness doesn't remember the judge saying anything other than you don't need a lawyer. Didn't go over, well, you have a right to an attorney. Are you giving that up? Are you waiving that? You have a right to trial. There's been no description of any of that. My client said it was in 10 minutes. It's put in front of the judge. Here's the deal. You don't need a lawyer. Sign the papers and go. Just a fine. If that's the case, Judge, then we have met our burden to prove that this was an uncounseled plea. The fact that there's a checkbox on a waiver does not save this plea, Judge. We have a prior judge who did not care about his client's rights, did not conduct a constitutional inquiry into his indigent status, and didn't secure his rights. So whether or not my client later on down the road accepted a DWI second, whether or not he accepted a felony and took those pleas, that doesn't make that 1986 plea okay. As a matter of fact, Judge Johnson v. Zerks, in the brief that we filed with the court, has a great line which I'd like to quote. But it says that every it talks about how the state of Texas does not condone these kinds of pleas. That Your Honor should be very careful about accepting the plea that's described in this case. Judge, I also prepared a brief which I filed, and it has, but Johnson v. Zerks is very clear in Texas law, Judge, that an uncounseled plea is an abomination and that it should not be used to enhance other pleas, which is exactly what happened to my client. So just because he has later accepted DWI second, accepted a felony, that does not mean that the initial plea, that doesn't bless the initial plea or say that that's okay. As a matter of fact, all it means is that we have further fights to fight in other courts, possible ineffective assistance claims, possible other claims about what should have been looked at in those cases. But the point is, Judge, that what's before this case is not what happened in Fort Bend. It's not what happened in Harris County a few years later. Those cases just prove why this client is still suffering from the consequences of that 1986 plea. Because this snowball, Judge, and the federal government and the state chose to use this conviction, which was 30 plus years old, which they didn't have adequate records of. They chose to use it in 2006 when these records were already destroyed. And the federal government chose to use it when he came back to Mexico recently against him. And so the fact that this is an old plea, the records are destroyed, should not be used against my client because the state has chosen to relitigate and bring this old plea back up. And he has a right to have counsel look at the plea and see whether or not it's constitutionally sound.
Emily?
Yes, Judge. First, I received the bench brief right before we started, so I haven't had a chance to look at it, but I can respond once I have a chance to look at it further if you want a response to it. I'm going to start with just the writ in general and then talk about latches. So what we learned today is that he remembers some stuff that is important to his writ, but doesn't remember a lot of other stuff. So I think that everything he says should be considered whether or not he's saying it in hindsight after the fact to benefit himself, or if is he only remembering the things that help him, or is he saying things that help him so that he can get the conviction overturned? For instance, he remembers signing plea papers, which would be very helpful if we had those today to see, did he possibly sign something that said, I am waiving counsel and I understand that I'm waiving counsel and I'm doing this voluntarily? We'll never know because of the passage of time. But also, the writ has to prove clear, affirmative proof to the contrary of an intelligent waiver of counsel. The record here is not silent. We have evidence that he intelligently, voluntarily waived counsel because of the checkbox on the judgment. So in order to overturn the conviction, he needs clear and affirmative proof that shows otherwise. And today's testimony just muddied the water more in terms of, was there a waiver? Because now we know that he did sign paperwork. We just don't know what it says because he didn't read it. And unfortunately, we don't, and now we don't have a copy of it because of the time that has passed. In terms of his memory, he did have an enhancement abandoned in this case. And everyone that works in this building knows that most of the time that is due to some type of plea discussion where the DA is talking to the defense attorney or the pro se defendant and saying, we'll abandon this enhancement if you plead guilty, and here's what's gonna happen. But he doesn't have any memory of the DA or talking to them. So we don't know how that came to be, but it is a question of how did it come to be that they abandoned the enhancement of the over 0.15, which is shown in the judgment. Also, he admitted that he did not ask any questions. When he was confused and didn't understand what was going on, that would have been a time to him ask questions and stop and not sign the papers. He also said no one threatened him, he wasn't forced to do this, he did it on his own. But I think the biggest issue is the 1989 case, where everything we assume when it's planned, he had an attorney, the attorney explained it to him, and the attorney would have explained to him, you're pleading guilty to a DWI second. The judge would have explained to him, you're pleading guilty to a DWI second. That would have been the time to question, why is this a second if I never pled guilty to a DWI first?
My question more so is this. And JP, when you have, I mean, let's think about this, right? When you have a felony DWI, you know, part of the elements of the case are what? The 2 prior DWIs, right? They're not enhancements, they're elements of the case. So presumably you've got this DWI, you've got the 89 DWI. By pleading guilty to the felony, have you not pled guilty in this case again? It's a second plea of guilty.
No, Judge, and that is exactly the reason that Johnson v. Earps, that is exactly the reason the state of Texas says uncounseled pleas should not be used to prove enhancements for that exact reason, because a plaintiff, a client of my client, who was constitutionally, his rights were trampled in 1986, he gets injured twice incorrectly.
Does he not have the ability to challenge it at that time?
He's challenging it right now. Judge.
Okay, yeah, because of the federal government has gotten involved, but
Yes,
why
Judge.
not?
We also don't know, there might be a chain of ineffective assistance here. The 2006 case, I think that absolutely, and I don't want to take our focus away from what's before this court too much, but I think there is an effective assistance of a counsel who took a plea when there was paperwork that was completely missing, and my client's story was so readily available. When looking at the plea paperwork shows an uncounseled plea, I mean, it was a red flag for me. I think it should have been a red flag for any other counsel. The judge, just because a counsel didn't pick it up in 06, doesn't mean that, it just means that that's the reason my client's he was unaware that he had the ability to challenge this until we raised it. It doesn't detract the fact that, well, he should have raised it in 96, he should have raised it in 2092, he should have raised it in 2006. That doesn't change whether
We have
this
time and time and time and time. But for the federal government deporting him, right, would we be here?
Right, Judge, you're absolutely right, but that doesn't mean that the 1986 plea was correct. It doesn't bless it. It doesn't, as a matter of fact, John, the case law says that the reason that we rely on judgments is because they're final, because of they're final and we just kind of have to move on. But what makes them final, what allows the state to bless this is that it was constitutionally sound. If it was not constitutionally unsound, if it was unsound in 1986, then there is no reason to uphold a final judgment. There is no reason to bless it with, well, it's been done. If it was wrong then, Judge, it's wrong now. And the quote I was scrambling for earlier from Johnson v. Zerps, 304 U.S. 458, is courts indulge every reasonable presumption against waiver of fundamental constitutional rights. There's no more fundamental constitutional right than the right to an attorney. It was established in 1963. If you believe my client about what happened in that court, Judge, that judge didn't care about his constitutional right to an attorney. He didn't care about his indigency status. He made the decision for my client that this is just a fine, it's not going to affect you. And you can't bless that, Judge. You have the ability, in life, we don't always have the ability to fix things. Sometimes we do just have to move on. But you have before you the ability to fix a 30-year-old plus wrong, Judge. I urge you to do it.
May I respond?
Yeah,
And continue?
briefly.
The applicant's talking about unconstitutional pleas. But it's his burden to prove that this was an unconstitutional plea. And the only proof we have of that he is presenting, which the court can decide if it is credible, is the testimony of the applicant that in 1986, he remembers certain things that are helpful to him, but he doesn't remember other things. In particular, he doesn't remember giving his thumbprint. And so if that is enough to prove that this was unconstitutional, then we can get into the case law on how you can't uphold a plea if it's unconstitutional. But as of now, on the face of the JNF, on the judgment, it says he waived counsel knowingly, intelligently, voluntarily, and so now he has to overcome that. And the only evidence they presented is the testimony you heard today. The next issue, latches, is a serious concern in this case, obviously, because it's 39 years old, 39 years later, and we don't have the documents. The state is in a bad position to even argue against the writ because all we have is the judgment. And now we know there were papers that he signed, but we have no idea what they said. And so that puts us, that is prejudice on the state to not be able to have that. And if this is overturned, there is no way we could try this case or prosecute this case based on evidence from 1986 that we have to figure out if it exists, figure out if the officers are still alive, figure out if the breathalyzer tech is still alive, all those type of things. And so that's why latches should absolutely apply in this case because he had multiple opportunities to raise the issue in 89, in 2006. He could have raised the issue and filed a writ, but did not. And so that's why the state's asking that you deny the writ.
Can I respond to those? I don't think I got a chance to respond to the last argument.
Well, no. Let's do this because you filed a supplemental brief on it.
Right.
And I want to give her a second to look at it. So why don't we take a couple days? Let's finish the argument. I mean, it's now, we've got a bunch of people waiting anyway. So today's Wednesday. Why don't we come back on Monday, take a look over that time and then, be ready and do like a final argument on that time. And then I'll rule on that day. Because I want to give you a chance to see the supplemental brief and then.
Yes, thank you, Judge.
Yeah, okay.
10:30, same time.
Same time. Monday. Yeah, okay.
Thank you, Judge.
Off the record. Okay. Thanks for being patient.
Judge,
Hey,
on Ms. Tarani, she's been throwing a lot of things today. We're trying to work out scheduling. I know you said you want us to come back in a week. Is there any way we come back on 17th of April? That's in a couple of weeks, maybe 2.5 weeks, but that's the next day. She's off work that day. She's already taking off work. And we're trying to figure out when she can pick these days. She's basically got her schedule planned out all the way through the end of the summer.
Okay.
She's gonna have to
Fine,
readjust.
reset it to that day.
Okay.
Okay,
Thank
but
you.
that's,
I get it.
be ready to pick a day in May for her. Like, I'm not gonna set it another 3 months for her to do the 10 days. So she's gotta be
Okay.
ready for in May-ish
I
to do
got
the time.
Okay.
Okay, so mark that down, please, so we don't forget. Okay. Mr. Paulin, always a pleasure, man. What's up? What's your cause number? Okay.
And Andy Kahan,
Oh, sure.
he's a friend. He said he wanted to be able to get her to
Is she,
use her for pretrial drug screening on April 8th or 9th, if she is attending a victim event.
that's fine. Just let them know.
The governor and.
Not a problem. Just let Veronica know.
Okay, so I want to get you, okay.
Great to see you.
Good to see you.
Hi, LaKayla. How are you, man? Yes.
She pay her $30. She got paid now for her dismissal.
Sure.
That's all.
Yeah, we'll roll it tomorrow.
Okay, thank you.
If she doesn't have it done tomorrow, then I'm gonna roll her the next day, and I'm gonna roll her the next day. So please have her go pay it. Okay, good. All right. Thank you for coming back. I know how busy.
Judge, you tell Mr. Barrientos he can log off.
I didn't hear you. Oh, ya te puedes ir, señor Barrientos. Terminamos. Do you want to go through the list? Yeah. So the assault's going to be dismissed. Okay. I'm not gonna order no threatening or harassing. I'm gonna order no contact while he's on this deferred. He's drinking alcohol. But the reason we are here on both cases is because of one thing. It's because of the alcohol. That's the sole factor that continues to happen in this case. The only thing I asked you not to do was consume alcohol. And, you know, you did all this, you did all that to prove to me, yet here we are with yet another violation. My fear is that it continues to happen. The next time you may be looking at a 3rd-degree felony, 2 to 10 of the penitentiary. Do you get that, Mr. Ortiz? You don't. Because otherwise, maybe wouldn't be here on another violation. And the last thing I want is to put you in jail for up to a year, because that's what you're looking at the next time. You know, there are times when we try to intervene before something catastrophic happens. And we tell you, okay, please stop. It happens again. Please stop. We told you again. And it happens again. Please stop. It happens. I don't want something catastrophic to happen. Do you understand? You've shown us time and again that you're not willing to comply. This is why we do the things we do. If we were doing this and there weren't any violations, then I would bless it all day. But with the continued violations, I don't want you to have contact with this person. Do you understand?
So would you consider, continuing the breath device, like this noise I'm taking, is it leave them in, language as it is? That, I mean, you know, Judge, I think his eyes were open.
What does he have now?
The portable breath device, is that correct? Portable breath device from.
Do we have, you know what I would do is the scram. So I know it's on him at all times, and then I would consider it. Yeah, I will, but the only way is with a scram, so I know it's on him 24 hours, 7 days a week. And I'm telling you now, any violations, you're looking at inpatient treatment over and over and over tells me that there is an issue. Do you understand? You may very well, because the inpatient programs that we have, it's a minimum of 9 months in the jail where you will wait for weeks for a bed. If you respond well to treatment, it's a minimum of 9 months, up to a year and a half of your life. Do you understand? I'm not asking for much, but I want my public safe, and I'm going to do everything in my power to protect it. Do you understand? So until he's got a scram on his ankle, no contact. You're charged with violation of a protective order or bond condition. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred. This is a type of probation that if you complete successfully, there's no conviction on your record, but you give up so many rights, Mr. Ortiz. You violate this thing, and I don't care how minute you may think it is. You're looking at a year in jail. Do you understand? I will issue a warrant for your arrest. You will go to jail. We will bring you out, and we will have a hearing to determine if you violated this. And if you do, you're looking at an entire year. You understand? This means no alcohol, no illegal drugs, no weapons. For now, no contact with the complaining witness until we give you approval. You cannot get it on your own. You leave here, you are not allowed to have contact with this person. Do you understand? Not until you come back and you get approval from us, and we want to know that you have the device on your ankle. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it successfully or it gets revoked. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty, and I'm going to order you to undergo. Have we done a TRAS in this case?
No.
Let's do a TRAS. You will do a thinking for a change. No drugs, no alcohol, no contact with Mr. Palos. There is also an affirmative finding of family violence, meaning you ever pick up one of these cases again, you will be facing a 3rd-degree felony. Do you understand? All right. Good luck to you, sir. Thanks, Hector. So if you get it tomorrow, come back and then we can do it tomorrow.
Okay.
But not until I know
Yes, sir.
that 100% there's no way that he's going to have any alcohol. This way, if he doesn't blow with this thing, if he doesn't blow, we'll never know. And I'm not going to trust someone else's life on it.
Understand you.
All right, ready?
Yes, Sean. So I'm here on Mr. Doherty, Your Honor. We submitted the PT application this morning on Doherty, Your Honor. So I want to see if I can get it to you guys, please.
Yeah, of course.
That's it.
You're at 140 days, so I don't care what you do.
Okay.
Yeah, have fun.
Thank you.
Hey,
I need to resolve that with more information before she goes to take.
Yes, I'm Doherty.
okay, I'll reinstate it then. Yeah, and then we'll SFB up tomorrow to make sure it gets done. Yeah, okay, thanks. Are you ready? Do you have Mr. Black or Miss Black? Miss Black, come up. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand, ma'am, that you're entering into a lifetime decision today. Once you plead guilty to this offense, it goes on your record. It will be there for the rest of your life. You can never take it off. You understand? You also need to understand that every time you get pulled over from now until the day you die, officers will see this DWI. If you smell like alcohol or dope, what do you think is going to happen? Very, very possible. I don't know for sure, but I know it's possible. And what else I do know is that from now on, you will be facing a minimum of 30 days in jail. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned and charged right to no court if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This agreement is final today. You can never change it. Is this what you want to do, ma'am? How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. I have to suspend your license. I'm going to do it for the minimum, which is 90 days. Do not drive until you get a license. Good luck to you, man.
Good.
We will
Maybe address
CC.
the issue of the mandatory.
I'll CC it.
All right, thank you.
All right.
Judge, also bottom of 15, how much time on that one?
Owen, what are we doing on Laster?
Judge, we're trying to fix that driver's license. We got one case left, we're hung up on. Hopefully I can finish it in the next 30 days. And they've already offered, if we fix it, they'll dismiss it.
Got it. Okay, so I'll give you 30, but she's got to be here to clear trial in the next setting.
Okay.
Okay. Hi, Adam. How are you, man? Please, just the last name of your client. Oh, great. All right. So, every time you miss and you have a bond violation, the same thing occurs. You were just spending money on going to jail, enriching bonding companies. I'm now going to put a device with you so that I know that you're not consuming alcohol. Any more violations? Next time, double, triple, quadruple the bond. Do you understand? Okay. All right. Got it. Please. Portable device. Yeah. Hey, who's the gentleman in back? With him? Who else is there?
You already voted on it, right? Yes, you already voted on it. You already voted on it.
The previous.
Wednesday, the 28th. All right, required. Thank you. Okay, see ya. Judge, you ready?
Yeah, let's go. Come on.
Top of 7. Maybe all the files, those still here.
5002.
You know?
Yeah. Does he have 2 cases or just 1?
Judge?
Okay, both at 5002.
Okay, both of them. All right.
Yeah. Hi, Juan.
Hi, Judge.
How are you, man? Of course.
I have Anthony Williams.
Okay.
It's a suspended license case. The hold was the out-of-state tickets that he's paid. However, they're still showing up on the system with TPS.
Oof.
It does give an alternate for him to show the receipt to the DPS and to pay the 205 reinstatement fee. But he did show me the receipt where he paid $1,658 to Louisiana on their municipal tickets. That was holding.
But the problem is that when you just pay the tickets, you incur more suspensions as opposed to doing something different.
Well,
Like
there were outstanding tickets. So it wasn't, and I was Louisiana, so it was out of state compact.
what I'm getting at is that by paying those
You're
tickets,
admitting guilt and.
you're gonna get, come up. Are you Mr. Williams? Come up. I understand that you paid, but the problem is that every time you get a ticket and you just say, look, I'm just gonna pay this to go, it's, what is it? It's more points, more this, more that on your license, which in turn may suspend it even longer and longer and longer and longer. Every time you plead to something on your license, it may impact that license, incurring further suspensions. So you may, by thinking you're just going to do this, just maybe incurring further suspension of further suspensions. That's why you need that. The reason I gave you a lawyer is for you to talk to the lawyer about the tickets to figure another solution instead of just incurring the vicious cycle of suspension after suspension after suspension after suspension, and now it keeps going.
So from what I can see, Judge, on it, these were tickets from May of 2013, and they had been found guilty. Just the tickets were out, the fines were outstanding. But and then the DPS entered their suspension under the
uniform right
in October.
It's a full faith and credit clause. What happens in another state's going to recognize it. It's the Constitution.
Right. And so, and the DPS is saying you must provide proof of payment from the out-of-state court where the citation was, or complete the money order form back and forth, or the copy of the front and back checks. And this was actually, he went down there to go pay them. It was closed, so he paid them online. And so he needs to submit this to DPS so that DPS can look that along with the 205 reinstatement fee.
But we don't know for sure if they're going to further suspend a license by virtue of him paying just the $1,600 on all these tickets, right? What do you know? What kind of tickets they were? Were they moving violations? Okay, it's.
I think it's different when he had already been found guilty of them and tickets were outstanding rather than admitting guilt now on them.
But by paying them, you're pleading guilty to it.
Which in effect had happened back in 2013.
What do you mean?
The tickets were.
Did he plead to him and just not pay it in 2013?
That's what I'm showing.
Or
the records on that.
Or did he just now plead guilty and pay the fines to it?
Which one was it?
I never went to court and lose out.
So
like pleading guilty right now after everything.
Right.
About paying
that's not good.
But I had spoke with him while I went to the DMV down there. They told me that I couldn't get my license because of the whole of Louisiana. They told me I had to pay the ticket off, pay them off first, and then come down there and pay them the 205 for the reinstatement fees, and then I'll be able to get my license. And that's what I thought I was supposed to do.
Can I ask for 2 weeks for him to get with DPS to see if they're going to reinstate it or not?
Yeah, but at that next setting, it's clear trial though.
Yes.
I mean, we just can't just.
And my conversation with him yesterday was like, I don't show anything new. And then he says, but I paid them. And then when I see the receipts, they're paid on March the 6th. And so that's